Can you guys hear me? Hello, I'm Eric Blank, and this is a Commissioner's Deliberation meeting in 21R-0538R, the rulemaking on railroads. Ms. Harper, you want to get us going?
Good afternoon, Commissioners. Ruthie Harper of your Commission Council. This matter comes before the Commission for consideration of the exceptions filed by rulemaking participants to recommended decision number R23-0618, issued September 22nd by Administrative Law Judge Melody Merbaba. The recommended decision adopts amendments to the Commission's rules regulating railroads, rail fixed guideways, transportation by rail, and rail crossings. The following rulemaking participants filed exceptions challenging portions of the recommended decision and requesting clarifications or modifications to the recommended rules: Union Pacific Railroad Company, BNSF, Railway Company, Colorado Communications and Utility Alliance, and the American Short Line and Regional Railroad Association. Responses were filed by CDOT, CCUA, the City and County of Broomfield, Boulder County, and Douglas County. I will go through the general issues raised in the exceptions as well as the specific requested rule changes. If you agree with this approach, first I'll address two overarching challenges to the recommended decision and the rules. Next, I will address the preemption and constitutional assertions. Then I will review the specific requested rule changes. And finally, I will touch on two general requests concerning implementation. If you agree, I will go through several related decision points at once and then pause for your discussion and vote.
That makes sense to me. Why don't you keep going, Ms. Harper?
Okay, I will start with two general challenges. First, BNSF contends that it would be arbitrary and contrary for law for the Commission to have the ability to impose a civil penalty on a railroad, but not on the road authority for the same failure to comply with the Commission rule or order. BNSF also contends that RTD operates a railroad and should not be exempted from civil fines. I recommend denying these exceptions. As the ALJ found, the Commission's finding authority in 44-106-1B does not include road authorities. While the Commission has authority to assess civil penalties against public utilities, road authorities are not public utilities under state law. As to RTD, the ALJ properly found the legislature excluded political subdivisions like RTD from the finding authority that's conferred in 44-106-1B. That section empowers the Commission to fine a railroad company, but the way the law defines railroad company excludes political subdivisions like RTD. Second, under these general challenges, BNSF disputes what it claims are references in the NOPR and the recommended decision to a pattern of delay, intimating that railroads are responsible for such delays. I recommend denying these exceptions. The record contains credible comments from road authorities detailing their experiences of delay and non-responsiveness when working with railroads on rail crossing projects. The ALJ specifically reviews many of these comments in the recommended decision. Overall, the record demonstrates there is a real need to improve the processes and communications between the railroads and the road authorities and better facilitate the proper and timely completion of Commission-approved rail crossing projects. The rule amendments are designed to do just that. I'll pause here for your discussion on these general challenges.
Geez, the allegations of delay are really troubling. Commissioner Plant, comments, questions, discussion, or a vote?
Yeah, I mean, I'm ready to vote. Do you want to vote on both, or are you looking for to do them one by one. There
Ms.
was-
Harper?
I think for efficiency today, since there's a lot of points, I've set it up that I'll pause after going through a couple of different decisions, and then it would be a vote on all of the ones that I've just discussed.
Okay, so
You're
yeah,
voting on the recommendation.
Correct. And the recommendation would be to deny these two exceptions I just went through that are sort of general objections to the rules and the decision.
I agree with the recommendation.
Commissioner Gilman,
I also agree, Ms. Harper.
as do I.
Next, I'll move on to the preemption and constitutional arguments in the exceptions. BNSF and Union Pacific assert that the Commission's rules are either preempted or unconstitutional and must not be adopted, at least in the form recommended by the ALJ. BNSF argues that the ALJ's determination not to address these arguments represents an abuse of discretion. I'll start here by noting that BNSF and Union Pacific poorly present these arguments and their exceptions. As to substance, the arguments contained in the body of BNSF's exceptions are underdeveloped and conclusory. BNSF does not present the balance of its arguments in the exceptions, instead citing to reasoning scattered across various pages of an attachment to its exceptions. For its part, Union Pacific provides even less. It addresses the 5 constitutional arguments it seeks to raise on exceptions with only 2 sentences, relying on footnotes citing to various pages of comments filed in this proceeding and another. Though Union Pacific has failed to properly present these issues for the Commission's review, because BNSF has presented these, at least marginally, I do recommend addressing them, at least to confirm that the Commission does not find a cause in these objections to reconsider or reject any of the recommended rules at this time. First, the railroads contend that the rules are preempted because they impermissibly intrude on the jurisdiction of the Federal Surface Transportation Board, or STB, and impermissibly burden interstate rail transportation. I recommend finding these arguments are unpersuasive to compel the Commission to consider modifications to its rules. The arguments presented failed to meaningfully develop the legal analysis that is utilized to determine whether state law is preempted. Read together, the cases the railroad site failed to develop an analysis that tests a specific state law or regulation against the ICCTA or the regulations of the FRA or the STB. With one brief exception, the arguments do little more than make general assertions about the rules and claim that they are preempted. Further, these rules regulate rail crossing safety in the Federal Railroad Safety Act, not the ICCTA, which the arguments focus on, governs whether state rail safety regulations are preempted. I'll turn next to the constitutional arguments. In their exceptions, BNSF and Union Pacific assert that the rules and the proposed civil penalties are unconstitutional on grounds that they violate the Equal Protection Clause of the 14th Amendment, impair the freedom of parties to contract, discriminate against out-of-state entities, and constitute an excessive and inappropriate exercise of state powers. Upon review of the exceptions, I recommend declining to dismiss this rulemaking or considering any further modifications to the recommended rules. As to equal protection, the railroads contend it's not rational to treat road authorities differently and that removing some stakeholders from civil penalties is facially arbitrary. But as the recommended decision points out, the Commission lacks statutory authority to assess civil penalties against road authorities. So I see no grounds here to find it as irrational or a violation of the 14th Amendment for this Commission to enact civil penalty rules that align with the statutory authority the legislature has given it. As to freedom of contract, the railroads contend the rules impair the freedom of contract by allegedly dictating terms, mandating templates, imposing time limits, and limiting safety consultants. Despite the seriousness of these claims, BNSF offers only a quotation from the contracts clause and a lone case citation. And the case that it cites is unpersuasive because the proposed rules apply prospectively to proceedings initiated after the rules become effective. To support the claim of in-state favoritism, the railroads contend the road authorities are being treated than railroads. But I recommend that you reject this attempt to read discrimination into the amendments. BNSF frames the issue as road authorities versus out-of-state railroads. However, even the two cases it cites to support this argument indicate that the proper comparison is between similarly situated entities, which here is railroads. To the extent the railroads argue that the civil penalties are precluded by the Commerce Clause because the impact is disproportionate to its benefit, I see no merit to their argument. As the ALJ pointed out, these rules advance legitimate interest in ensuring that railroads comply with statutory obligations, commission orders, and commission rules relating to crossing safety. So I recommend not considering any changes to the rules on these grounds. Finally, regarding police powers, the railroads disagree that the recommended rules promote safety. Indeed, they argue many rules would hinder safety. But BNSF's argument on this point should not persuade you to depart from the clear analysis and findings in the recommended decision that explain why these rules promote and further crossing safety in Colorado. At their core, the rules will help ensure that crossing safety projects proceed on schedule. BNSF's undeveloped assertion that the rules do not promote safety is unconvincing. So I'll pause here for your discussion and vote on these recommendations to the preemption and constitutional arguments. And again, the recommendation is to deny all these exceptions and not find any merit in them that would warrant you dismissing the rules or considering any changes at this time.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gilman,
I also agree.
as do I.
I'll move on now to the specific requested rule changes. I'll discuss all the changes to a particular rule and then pause for a discussion and vote on that rule. First are the rules 7,009 through 7,011, which address civil penalties. Both BNSF and Union Pacific raised logistical concerns with the process around assessing a civil penalty. BNSF cautions that road authorities could use the threat of civil finding as leverage in proceedings before the commission. BNSF requests, at minimum, the rule should state that railroads can present exculpatory evidence demonstrating the delay was caused by the road authority. Union Pacific objects that the commission's notice to a railroad of an alleged violation could be the first time the railroad even hears of an allegation and would only have 14 days to cure. Union Pacific posits that a more reasonable process would be for the commission to set a status hearing in the proceeding to determine the cause of delay before proceeding to a CPAN. Union Pacific also requests the commission extend the timeline to 60 days for a railroad to cure an alleged violation or pay a prescribed penalty. In response, Douglas County counters that road authorities do not themselves benefit or receive any monetary gain from arbitrarily requesting that the commission fine a railroad. Douglas County states that railroads can avoid these penalties by standardizing their development of schematics, estimates, and agreements and committing to an actual timeline to deliver these documents to the road authorities. I recommend denying these exceptions to the logistics of the CPAN process. The ALJ reasonably found the due process afforded to CPAN respondents under the rules will adequately ensure the railroad's concerns with unfounded allegations are not ultimately realized. To Union Pacific's suggestion of using a status conference, while this is an available tool, I do not recommend prescribing this in rule. I also recommend not extending the cure or the payment period. The rules already have flexibility. For example, as to the cure period, the rule states a minimum of 14 days must be allowed for a cure, and the commission in its discretion may provide additional time for a cure. Also relating to this rule, BNSF and the short line railroads object to the amount of penalties that may be assessed. BNSF requests that the commission further limit this amount. For its part, the short lines, who are referred to as ASL-RRA, objects to a one-size-fits-all approach, saying it is harmful to the small business railroads. I recommend denying these exceptions. As the ALJ emphasizes, the rules do not impact the railroad's operations, but merely allow the potential for the commission to enforce the Colorado Constitution, Articles 1 to 7 of Title 40, and its orders and rules through civil penalties on a prospective basis. In addition, in determining the civil penalty amount after an adjudication, the commission will take into consideration relevant factors, which also addresses the short line's concern. When the commission assesses a civil penalty, it considers factors including the respondent's ability to pay, the effect on the respondent's ability to continue in business, the size of the respondent's business, and any other factors as equity and fairness may require. Finally, as to this rule, the ASL-RRA renews its request that the commission engage in a partnership with the FRA and its Rail State Participation Program as an alternative to adopting these rules. I do recommend denying this exception. The ALJ also rejected this, as the ALJ concluded, while the FRA's program could have other benefits, it does not advance the commission's interest in enforcing its orders and rules and relevant statutes. So I'll pause here for your discussion and a vote on these recommendations regarding the civil penalty rules.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gellman,
I also agree.
as do I.
The next rule for discussion is proposed rule 7202 from the NOPR. This rule clarified that any owner of a track at a railroad crossing must be joined as a necessary party in an application. The purpose of this requirement was to improve efficiency in the application process, but the ALJ concluded the rule may do more harm than good and declined to adopt it. In its exceptions, BNSF again urges the commission to adopt this rule, reasoning this procedural mechanism would alleviate the burdens on railroads of having to file interventions. Responses were filed by Broomfield, Boulder, and Douglas County, urging the commission to deny this exception. I recommend the commission deny this exception. I agree with the ALJ's conclusion that automatically joining a railroad as a party to an application proceeding may ultimately do more harm than good. Most problematic, it could create confusion whether the application is actually contested or opposed. So I'll pause here for your vote on denying this exception.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gellman,
I also agree.
as do I.
The next rule is 7208E regarding notices. Union Pacific requests modifying the language of this rule to permit it to list its centralized contact center as the designated person to receive certain notices. Douglas County filed a response raising concern that road authorities and the commission need to know the correct contact for the designated Union Pacific representative for Colorado. I do recommend granting this exception based on Union Pacific's representation that the contact center operates 24/7, provides responses, and ensures that the communication is directed to the appropriate Union Pacific department. It seems reasonable to adjust the language in the rule to allow this designation. However, the order can make clear that Union Pacific assumes the risk that any critical notices sent to this contact that start timelines under the rules will be routed through this contact center. So I'll pause here for your
Commissioner-
vote on this rule.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gilman,
I also agree.
as do I.
The next is just a request to correct the cross-reference in Rule 7211K. The cross-reference should be to 7301D. I do recommend making this needed change.
Not sure we need a vote on that, but Commissioner Plant,
And the mistake. I agree with the recommendation.
I
Commissioner
agree.
Gilman, as do I.
I'll move on now to Rule 7212. I'll discuss 4 areas of exceptions to this rule and then pause for your vote. First, Rule 7212C states that during a field diagnostic review, the road authority and the railroad, with any necessary assistance by commission staff, shall review and confer on safety devices, preemption and timing of traffic control signals, and the exit gate operating mode and clearance. The rule specifies while this conferral is required, the railroad does not have authority to overrule the road authority's determinations as to aspects that relate to control and direction of vehicular traffic. BNSF objects that the rule is ambiguous and could improperly give road authorities sole authority over the selection of devices and preemption times. In response, Boulder and Douglas County argue that state railroad consultants are themselves not experts in a crossing's vehicular traffic characteristics and often request traffic or pedestrian features that are not necessary. I recommend denying this exception as the ALJ concludes road authorities with the commission's approval are best situated to make decisions concerning design elements related to vehicular traffic as they are able to bring their traffic engineering expertise to bear. Second, under this rule, Rule 7212E sets out a timeline and a process for the initial cost estimate and a schematic diagram, and for necessary documents for the railroad's development of these. BNSF contends the rules do not sufficiently require provision of all necessary information to a railroad before it's required to provide these documents. Broomfield, Boulder, and Douglas County all filed responses agreeing that necessary information must be provided up front, but cautioning that road authorities should not be unnecessarily delayed by the inability of a railroad or its consultants to fit a needed diagnostic meeting into their schedule. BNSF offers in the alternative, the rules permit more than 14 days for a railroad to provide a written request to the road authority for needed additional documents, allowing instead 30 calendar or 21 business days. Union Pacific makes a similar request. Douglas County responds to this proposal stating necessary documents should only include those showing railroad features under the authority of the railroad. I recommend granting this exception in part and denying it in part. I recommend adopting BNSF's alternative approach, adopting a change that allows 30 calendar days for a railroad to provide its written request for additional documents. I do not recommend any adjustments based on Douglas County's response, but I do agree that railroads must be realistic. To that end, the order can clarify this rule is not to be used as a means to circumvent other rules, and that the necessary documents that may be required on this rule refers narrowly to those documents the railroad actually needs to create the cost estimate and schematic. Also under this paragraph E, BNSF requests the commission extend the time frame for a railroad to provide the initial cost estimate and schematic from 90 days to 120 days. BNSF objects that it cannot meet a 90-day turnaround. Broomfield, Boulder, and Douglas County filed responses supporting this request to the extent it is achievable by the railroads. So I recommend granting this exception. This moderate extension is reasonable given the concerns that are raised by BNSF and the support in the responses. Third, under this rule, paragraph F states the signed construction and maintenance agreement must be filed with the commission within 90 days of the final decision authorizing the project, or within 30 days preceding the start date, whichever comes later. BNSF maintains this deadline is too restrictive, absent an agreement on templates. Union Pacific objects to the establishment of any fixed or project's schedule, arguing it would only cause further delays because each project is complicated and nuanced. Union Pacific requests at least the 90-day timeline should be extended to 120 days, arguing that verifying or identifying matters involving real property can take 90 days. Broomfield and Douglas County filed responses maintaining the deadlines in the rules should be maintained. I recommend denying this exception, as the ALJ found by establishing a deadline to file C&M agreements, this rule attempts to solve a common issue in rail crossing application proceedings. That is significant delay in executing C&M agreements, which delay stalls construction of a commission-approved crossing safety project. Also, once templates are developed, the process for executing C&M agreements should be even more streamlined, which provides another reason to retain the timing in this rule to incentivize the efficient use of template agreements. To the request to extend the timeline, I don't see merit to Union Pacific's exception stating that an adequate real property analysis can take more time. There's not enough in this argument to persuade the commission to extend the timeline. Fourth and finally, under this rule 7212, paragraph G establishes a framework for railroad consultant time and review. Both BNSF and Union Pacific oppose limiting railroad consultants' time. BNSF maintains any limits on the use of railroad consultants are arbitrary and detrimental to safety. Union Pacific states various personnel and consultants testified to the complexities of crossing projects and how road authorities' designs often lack the detail necessary for the railroad and its consultants to adequately review and approve plans. Likewise, both BNSF and Union Pacific oppose limiting railroad consultants' review of traffic engineering matters. CDOT filed a response asserting that BNSF incorrectly asserts that the road authorities restrict the ability of railroads to employ consultants. CDOT explains it does not oppose the use of consultants as a general matter, but it does oppose the broad scope for which railroads use their consultants and then bill the road authority. Broomfield, Boulder, and Douglas County filed responses similar to CDOT. I recommend denying this exception. As explained in the NOPR and the recommended decision, this rule is intended to minimize delay resulting from railroad consultants' involvement in public projects, which can lead to public safety concerns. The ALJ found, and I recommend upholding, the record establishes that railroad consultants' work on public projects are a common cause of delay in moving projects forward, which creates crossing safety concerns. As the ALJ discusses, while road authorities have no choice in selecting railroad consultants or ability to direct the scope or speed of the work, railroads have routinely passed such costs on to road authorities. Further, the scope of the consultants' work has regularly included vehicular traffic engineering, which is an area for which road authorities have their own experts. I'll pause here for your vote on all of these recommendations regarding Rule 7212. Some of them were to deny, some of them were to grant in part.
Commissioner Plant,
I agree with the recommendations.
Commissioner Goman,
I also agree with the recommendation.
as do I.
The next rule for discussion is Rule 7213. BNSF requests the commission modify this rule to permit use of a stop sign rather than a yield sign as a minimum protection at a crossing without active warning devices. BNSF states the railroads and road authorities supported a consensus amendment to this effect, but the ALJ declined to adopt it because of CDOT's exception. objection. In response, Broomfield says it concurs with CDOT's objection. Likewise, Boulder responds it has also adopted the MUTCD, and Douglas County filed a similar response opposing the objection. So I recommend denying this exception. Upon review of the exceptions and the specific responses opposing any change, we agree that the commission's rules should meet the standards in the MUTCD. So I'll pause here for your vote on denying this exception.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gilman, as do I.
I'll move on next to Rule 7214 concerning template agreements. This rule provides that starting November 22nd, 2024, road authorities and railroads must use commission-approved templates for C&M agreements and preliminary engineering agreements. The ALJ explains the intent of this rule is to address the significant delay in executing C&M agreements. The ALJ also finds the record establishes that railroads have insisted, at least initially, that road authorities execute C&M agreements that violate or are contrary to or inconsistent with Colorado law. First, under this rule, CCUA requests the commission add to this list utility crossings for which templates will be developed. I recommend granting this exception and adding this to the list of templates. Next, BNSF allows it would participate in a workshop to create templates, but objects that the process in the recommended decision is too vague to be workable and provides no mechanism for dispute resolution. BNSF further objects that a static one-size-fits-all approach is not desirable for the many different communities and political subdivisions with which it must negotiate agreements across Colorado. I recommend granting this exception in part and denying it in part. While the process outlined by the ALJ is a good start, we understand the concern raised by BNSF, the potential for participants to reach an impasse. I recommend the commission indicate in its order that it intends to open a miscellaneous proceeding for this purpose, ideally no later than 30 days after the final commission decision in this proceeding. Through that decision, the commission can outline further how this process will be managed, including requirements for any workshops, which stakeholders may be asked to lead these efforts, requirements for status reports, and resolution of any disputes. Finally, under this rule, BNSF urges the commission to clarify that C&M agreements and related technical information filed with the commission should be protected as confidential. BNSF states this sensitive information implicates national security related to critical rail infrastructure. CDOT responds, objecting to any requirement that its agreements with the railroads be deemed confidential by commission rule. CDOT states it's a public entity subject to the Colorado Open Records Act, and as such cannot withhold these agreements. Douglas County also responds, maintaining public projects are public, and the information should be available. I recommend denying this exception. As BNSF acknowledged, the commission already has in place a set of procedures for how to file information as confidential. I recommend that the best approach to protecting any potentially sensitive information is through the use of these well-established rules and not adopting here any de facto treatment. I'll pause here for your vote on these recommendations to Rule 7214.
Commissioner Plant,
I agree with the recommendations.
Commissioner Gilman,
I also agree.
as do I.
I'll move on next to Rule 7301 concerning maintenance costs. BNSF acknowledges that the commission has existing rules concerning maintenance of equipment and disputes any claim that has been involved in extorting road authorities to pay for maintenance. BNSF also urges the commission going forward to consider whether commission rules concerning maintenance obligations that predate federal quiet zone standards are appropriate. Union Pacific states that it welcomes the opportunity to participate in the workshop process to develop templates, but it clarifies that federal authorities expressly prohibit states from allocating crossing maintenance costs to railroads when federal funds are involved. I recommend denying this exception. The railroads raise this concern, but don't request any specific rule change for consideration. The commission can acknowledge these concerns and address them in future proceedings. Also reiterate that the commission's rules regarding maintenance obligations went into effect before the federal quiet zone rule was established. So I'll pause here for your vote on denying this exception.
Commissioner Plant,
I agree.
Commissioner Goman,
I also agree.
as do I.
That's the end of the requested rule changes. I'll move on now to three requests regarding implementation of the rules. First, Union Pacific requests the commission allow a 1-year deferral prior to commencing any finding under the rules. It claims the rules essentially overhaul the railroad's internal processes, which will take time to address and change. Douglas County responds that establishing templates for estimates, schematics, and agreements would in fact help to expedite project documentation. I recommend denying this exception. The commission's finding authority derives from statute, not these rules. Although the rules provide more clarity and definition for this process, they're not necessary to exercise the commission's finding authority, which it has already had now for years. Further, because the rules will apply on a prospective basis, applying to proceedings initiated after the rules take effect, there is already built in an inherent phased-in approach. Second, Union Pacific requests that the commission include in rule a statement that the railroads may request an extension of any of the timelines, and such extension will not be unreasonably withheld. I recommend denying this exception. The commission's rules of practice and procedure already have a rule for waiver or variance of the commission's rules, and there's no need for a duplicative, possibly confusing rule. Finally, Union Pacific requests that the rules here follow the general principle of non-retroactive application and are not applicable to projects initiated before the effective date. I recommend granting this exception in part and denying in part. As I've already discussed, as a matter of law, new rules adopted by an administrative agency are prospective. As a result, the commission can clarify in its order that the amended rules will apply to proceedings initiated after the effective date of the amended rules. I'll pause here for a vote on these implementation requests.
Commissioner Plant,
I agree with the recommendations.
Commissioner Goman,
I also agree.
as do I.
That brings me to a final matter. I recommend denying the motion for oral argument. With their exceptions, BNSF and Union Pacific both requested oral argument to address the requested exceptions. But the record is clear, the recommended decision is thorough, and there are not any ambiguous facts or legal arguments that oral argument would help clarify. This rulemaking has already extended several years, and participants have had full opportunity to be heard through several iterations of written comments and multiple rulemaking public comment hearings before the ALJ. It's also infeasible to accommodate oral argument in the remaining procedural schedule, particularly with the delay caused by the extension of time to file exceptions at the railroad's request, as a commission decision must issue no later than November 28th. So I'll pause here for your vote on this final issue for discussion today.
Commissioner Plant,
I agree with your recommendation.
Commissioner Goman,
I also agree.
as do I. And I just say thank you, Ms. Harper, for leading us through it, and a real shout out and appreciation to the ALJ, who I thought did a really, really nice job with this process and the order, which I found to be really detailed, thoughtful, and well argued. So with that, Ms. Harper, anything else for us?
Just clarification if this can be ABC.
This can be ABC. Commissioner Plant, any final words?
Nope, I don't. Have a great weekend.
Commissioner Goman.
Enjoy your weekend, everyone, and just wanted to repeat the thanks to Ms. Harper for taking us through this, as well as our team and the ALJ. I certainly agree with your comments, Chairman.
With that, I think we're adjourned. Thanks, Ms. Harper. Have a good weekend, everybody. Take care.